Hi, everybody, and welcome to this special edition industry update with Damian Cox and Scott Peterson. As you all know, there is a lot of confusion out there in the marketplace with the NAR settlement changes that have occurred here recently. So we are here today to talk about frequently asked questions. And Scott and Damian are going to kind of jump into some content that they have planned. And once they manage to get through that, well, we'll be happy to take Q&A. So make sure and put that into Q&A as opposed to chat, and upvote for your favorite questions that you see being asked, so we can try to make sure and ask questions that are of interest to most of the crowd in attendance today. With that, I will turn things over to Damian and Scott.
Yeah, lots of stuff, Scott. Lots of fun stuff.
Yeah, I don't know. Fun is not maybe the right word. Sometimes you'll probably hear in my voice that I've been talked out over the last couple of months. But yes, it's exciting stuff, and we are. I mean, this is watershed moment in the residential real estate industry. I don't think there's any other way to describe it. And so it has created a whole bunch of I think opportunities for brokers that are realtors and licensees that are willing to embrace a change and respond accordingly. And I think we're going to see over the course of the next 18, 24 months, for a variety of reasons, a lot of attrition and kind of shakeout. It's kind of my personal prediction on it.
Yeah, and Scott, we decided to do this FAQ session because I know I've been inundated with a bunch of questions. I know you have been too. You want to kind of shed some light on why we're doing this? Yeah,
absolutely. We, excuse me. We started talking about doing this, I don't know, probably 3 or 4 weeks ago, because both of us, based on your direct client base and in my case, primarily through CAR's legal hotline, we've seen calls on the legal hotline go. Our average for years, I've been able to say we average in a 3-hour shift, typically right about 17 calls-ish, and 2 shifts a day. So about 34 roughly calls on average per day to the hotline. Been that way for years, very consistent. Up markets, down markets, doesn't really matter. Over the last probably 8 weeks, I would say now, maybe 7 weeks, but since all of this stuff really got right up upon us and certainly through it, and right up to now, frankly, we're averaging somewhere closer to about 55 calls a day. So almost a 100% increase in call volume. And out of those calls, I would say, 95% of them have to do with, practice changes, forms changes, how do we do this? How do we use this clause and whatever? And so you and I, in our discussions, and we talk, frequently, have kind of aggregated a list of some things that we find to be some of the most commonly confused or misunderstood issues related to both forms and practice changes and everything else.
Yeah, and I tried to put together, just based on our conversations, I've got an outline. I'm not going to share it because it's very, very rudimentary. It's just more notes for me, guys, so that we can try and stay on track. But I've got about 8 of them that I want to go through, and also have Scott give his opinion, obviously, on some of these things. Just the questions that I'm hearing over and over again, that Scott's hearing over and over again, and kind of help you guys understand how to navigate this. And I'll tell you, the biggest question, I think, overall overarching has been, should the seller be offering buyer broker compensation? Or and more importantly, should the listing broker be offering buyer broker compensation? And I'm just going to, real quickly say that my take on this is that brokers have been so used to having that offer of compensation in the MLS for so long that they've had the ability of just, business is this way and it's one way, and going, how do I do business? And it was just, you had an offer of compensation, you knew you were going to get paid, et cetera, et cetera. The whole landscape has completely changed. There is no one size fits all anymore. And I want you to take that perspective when we're going through talking about all of these things, that it's not just you do business one way anymore. There's a lot of factors that affect whether a seller should be offering the buyer broker compensation, whether the listing broker should be advertising that offer of compensation. And it's based on a whole bunch of different criteria. Scott, you want me to jump in, or you want to?
Yeah, I mean, that's the basis of the settlement. This is the basis of the lawsuit, is that commissions are negotiable, and certainly now they're more negotiable than they ever have been. And this is not something that's going to not continue. And so, yeah, I mean, such things such as to your point in your outline, market conditions. That's going to drive a lot of a seller's consideration for how and what and when to offer compensation. My analogy for when I get this question is, for years, builders, in what we would call buyer markets, where builders have to be more competitive for prospective buyers. When it's a true buyer market, like they're looking to give trips to Hawaii away to brokers and all kinds of incentives and whatever they can to really drive more buyer traffic. And then, of course, we know when it's more of a seller or builder market, you see a very different perspective in terms of their willingness to compensate, often the amount of compensation and everything else. And so I think that same exact theory extrapolates very directly to the private markets now, or residential resale markets now, for some of the reasons we've just talked about.
Yeah, and guys, the way I liken it is you have to know what a seller's motivations are, as far as when they're listing property. This is a conversation the listing broker should be having with sellers and finding out what is their particular circumstances, what is the current market conditions, what type of property are you selling. And one of the things I've been using as an example has been, two different contrasting markets. For many of you out there that lived through the old Great Recession days of 2008 and 9 in those areas, that was a different market than the pandemic. I mean, you had a very strong seller's market in the pandemic and a very strong buyer's market during the Great Recession. And you can see a seller who is in the pandemic and it's like, look, we're getting 50 offers in on this property and everybody's bringing cash and we got all this stuff. They may not want to offer compensation, and they might have a reason not to offer compensation because they're not worried about getting contracts in. But contrast that to the Great Recession, when there was maybe one buyer per 10 homes or something along those lines, and you had a seller that was facing foreclosure that needed to realize the equity out of their property, needed to move to Texas because they had a job they were taking down there within a couple of weeks. They didn't have any money. They were behind. They were accruing attorney fees and interest and default interest against their mortgage and everything else. Their motivation is not get as much money out of the property. Their motivation is just get something out of the property. And so, and I think there's a line in between those two markets too, guys. It's not just one or the other. Are we going to offer or are we not going to offer? But it's important to have that conversation with the seller, because for the seller to offer compensation to the buyer broker, there's really only one mechanism for them to do that and advertise, and that's through the listing broker. And so when you're having the listing broker in that 711 advertising an amount that they're going to be paying, that is the seller using that as a way to generate offers to say, hey, buyer, I'm willing to pick up one of your obligations here. I'm willing to pick up your buyer broker, or at least a portion of your buyer broker, in order to encourage you to make an offer on my property. And so that's really a conversation you have to have with the seller.
Yeah, and I would say though that it's within your standard of care as a listing broker, right? You've always had, as you enter into a marketing relationship with a seller on their behalf, you've got an obligation to help them understand the benefits and detriments of whatever marketing strategy you and your seller are going to employ based on their individual conditions, circumstances, timing, motivations, and everything else. And so this is just another factor in that. And so there's not a turnkey answer one way or the other for, whether or not your seller should offer compensation. The important thing that they understand as a threshold matter is that it's negotiable and that it needs to be considered as part of their entire marketing strategy that you're going to be helping them implement.
Yeah, and you and I were talking before about, when they're deciding whether they're going to offer that or not, it's the fact that buyers, if they're working with a broker, they're going to have an obligation now. I mean, that is one of the things that has come out of this settlement, is that every buyer that works with a broker is going to owe their broker something under some kind of contract. That's what the settlement did, is it said, hey, before you have a touring agreement, we're going to talk about that in a little bit on these touring agreements and everything, but it says that if you want to get paid, you can't get paid any more than what the buyer agreed to. So that means there is going to be an obligation in some form or fashion.
Yeah, when I say this is a watershed moment in residential real estate transactions, it's certainly not just for brokers. It's for buyers as well. Never before in history have buyers been conventionally in a meaningful way on the hook on a contractual basis, legal contractual basis, obligated to compensate their broker something. And so that is something that I think that sellers need to be mindful of, is that, you know, the buyer pool out there, it's gone from, you know, for practical purposes, like 0% of buyers that have been, you know, completely and totally obligated to pay their buyer brokers, or I should say a very small percentage conventionally, to literally 100%, because every buyer broker running around with a buyer needs to have their buyer on the hook to compensate them anything in order to ask for anything from the seller listing brokerage firm. And so the pool of buyers shrinks a lot, potentially at least, for buyers who are going to self-select properties and say, listen, I can't afford to pay you, buyer broker. I know I've signed this agreement with you, exclusive right agreement to pay you, but I need this money for my closing costs and for my loan and for, you know, moving costs and drapes or whatever, you know, whatever they need. I can't catch you this check for $10,000 at closing. So I don't want to be obligated. And so unless the property is going to be offering $10,000 to meet my obligation to you, then I can't afford to see it. So don't show it to me. And so there's a deeper nuance to that marketing strategy that I think sellers need to be aware of, and their decision in terms of how to respond to that is completely their own.
Yeah, agreed. The next question, I think we covered that one or beat it to death. So let's move on to the next one of, do I need to tell the buyer broker what the seller is offering? And I've heard this one a ton, and this is about, you know, you have paragraph 7, I'm going to call it 7111 so that everybody knows what I'm talking about. That's the part where the seller says, of the commission I'm offering to you, listing broker, this portion goes to the buyer brokerage firm or the cooperating brokerage firm, if there is one. And I keep hearing over again, sellers or listing brokers saying, well, I don't think I'm going to tell them what's in 7111. I think I'm going to wait for them to make an offer or tell me what they need, or I'm going to ask them what they need. You know, Scott, I know you have opinions on this, so I'll let you start and I'll chime in.
Yeah, I mean, I've gotten a ton of calls from, it's particularly buyer brokers who are calling and kind of frustrated because they're calling up to set a showing or calling up to inquire with the listing broker about the possibility or the whatever compensation, if any, is being offered. And the listing broker's response is, well, yes, there is, but that's none of your business, or I'm not going to tell you what it is, or whatever. And so that's been an incredibly common point of inquiry that I think you and I both have similar opinions on it. And that's this: as your seller is authorizing you through 7111 to offer compensation to a cooperating broker, potential cooperating broker, they're also instructing you to offer compensation to a potential cooperating broker. Presumably, the reason that they're agreeing to pay anything to anybody, including the cooperating broker, is because I have identified that that's a benefit to them from a marketing strategy. They wouldn't do it because they believe it's going to hurt them. They're doing it because they believe it's going to benefit them. And so if 711 has a number in it, percentage, dollar amount, whatever, that's not something that a listing broker ought to be playing hide the ball with when a buyer broker is making inquiry about what's being offered. That's inappropriate. I would argue very likely a breach of your fiduciary obligation to your seller, who's motivated to sell their property and obviously believes there's value in 7111 to offering compensation. And so I think that's bad behavior. There's a caveat to that, and maybe I'll let Damien talk about that. If there's language in the additional provision that makes it a benefit to the seller, then that might override what I'm saying. But on the pre-printed form, remember, as the exclusive right to sell has been drafted, if the buyer broker through the offer of compensation or the offer of compensation in the exclusive right to sell, if they're taking anything less than what's in 7111, that overage by default, with no other language in the contract, that goes back to the listing broker. And so that's where I have to check and see, like, wait a second, is this a motivation of the listing broker to potentially put additional compensation in their own pocket, or are they really doing this for the seller? And if all you have is the exclusive right to sell listing agreement executed, and you don't have any additional provision language in that shifts that money in sum or in part back to the seller, then I'm really struggling to figure out what the seller's best interest would be in not having you disclose 7111.
Yeah, and even I think I would go so far as to say, I go back to the discussion that we had about, the listing broker offering compensation out there. To me, that is about generating offers. That is about the seller making an offer to say, I'm going to contribute a portion to the buyer's obligation. And when you're setting that number, that should be something the seller is comfortable with, regardless of what the buyer broker has contracted for. And we're going to talk about that a little bit more in a little bit. But it really should be that they're looking at their net and what they're going to get with that being a cost of sale. That's what they should be looking at. And even if you have language in there that says that you can hide it or you don't have to tell and that the money's going to go back to the seller, what's the point of having it in 7111 then? When you're better off just putting 0 in 7111 and telling all the brokers out there, bring your offer, negotiate in 29.1, and the seller will decide based on your offer whether they're going to accept it or not. That to me is, you're not generating offers if you're hiding it. And to me, the whole purpose of 7111 is for the seller to have that out there, offering it to generate those offers and get those back in so that they can sell their property. And if you're not using it for the tool that it's intended, then you might as well put 0 in there and let everybody negotiate whatever they want to negotiate on that. The other thing I want to mention on this is, and Scott, I think you've seen this too, is these tiered commissions. So, brokers are so creative. I love their creativity. Just sometimes I question how logistically it works. And I'm not saying there's anything wrong with this per se, but what I'm seeing is, if the broker brings an offer for 850,000, then our commission will be X. If it's 800,000, then our commission is Y. And if it's 750,000, then our commission is Z. And obviously it's a decreasing amount based on that. And I mean, I guess I don't see an issue with this, Scott, like just from the standpoint of, is it legal or whatever? I think it's probably fine. What are your thoughts?
Yeah, no, I think it's fine. Unlike the buyer exclusive right to buy agreement, where you have to have an objectively ascertainable commission. You can't have a variable commission with a buyer. In your exclusive right to sell listing agreement, there's nothing about the settlement changes or practice changes, I should say, that preclude a variable commission in your listing agreement. I just think it sends a weird message. And I think it ties back to what you were just saying. If your seller is saying to you, either A, I'm not going to offer compensation, period, to a cooperating broker, or B, I might be willing to, but I don't really know what that is, or it's going to be variable, or it's going to be contingent on this or that, or I don't want you to say, or I want you to play hide the ball. Your best solution is put 0 in 7111 or in A, just get rid of that. Strictly negotiate your own compensation in 711. And then if a broker's asking you, the answer is either, to the extent your seller has said, no, they're not willing to offer compensation, then that's the answer if somebody asks. And to the extent that they might be willing to offer compensation, the answer is, hey, I've talked to them and they're willing to consider it. They want to see it in the context of a contract or an offer. Put it in 29.1 of the contract and I'll present it. And the other hiding the ball stuff or trying to structure some complicated tiered structure. Well, if you get us this purchase price, then we'll pay you this. You don't need to do it. Just put 0 or put in A and say, put it in the offer. And the tiered structure takes care of itself, because your seller is going to get a purchase price and an offer, and a 29.1 is going to have a demand for payment to the buyer. And if the two line up in the seller's eyes, sign the offer. If they don't, counter the offer.
Yeah, and I question how you would even advertise that. You have this tiered structure, and then you're going to advertise it and put it in, in a brochure on a listing, or it doesn't work in the brokerage firm compensation agreement at all, because you have no idea which one you're giving them, because you have no idea which offer you're getting, and you're supposed to have that before you do a contract. Just logistically, it just doesn't make any sense to do that tiered structure. You could just say, hey, the way my seller's looking at it, they're probably willing to contribute more based on what you guys offer in your purchase price. That's really going to be where this comes down, is what are you offering? And if you're offering more, then the seller might contribute more, because that's what they're looking at. So I think it's a mistake to put it in there as a 7111 number and put it in additional provisions or anything. If again, the way I view 7111 is that is a mechanism for you to advertise that the seller is willing to pick up a buyer obligation, and it should be used that way. It shouldn't be used as we're going to hide the ball and we're not going to tell people and we're going to try and maximize how much the seller. It's just not worth it. I mean, if that's what you're doing, then just put 0 in it and move it forward.
Totally agree.
Okay. Question number 3, and I see this a lot. Should I use 29.1, 29.3, or both? And I've seen a lot of contracts that have 29.1 and 29.3. And I also want to talk about the advantages and disadvantages of both of those and what that looks like, because I don't think people are understanding risks and things that go along with them. But go ahead, Scott.
Yeah, well, I'll let you take care of the disadvantages or advantages to 29.1 and 3, but you don't. So the scenario, and I've had the question a lot too. The scenario I've had is listing brokers going, well, I'm confused here. We got an offer, and the buyer broker who wasn't sure who was going to pay. Is it going to be the seller? Is it going to be the listing broker? They didn't exactly know when they wrote the offer. They just put the compensation in both 29.1 and 29.3. And so the listing broker is sitting here with the offer going, is this meaning that I'm going to double up potentially if my seller signs this? I'm not exactly sure, what this means. And I think it absolutely could, depending on kind of what's in the listing agreement. But bottom line is this: if you don't know and you're a buyer broker and you're preparing an offer on behalf of your buyer, then you should always put it in 29.1. If you haven't, let's say, and for a lot of reasons. Number one, if let's say there's going to be multiple offers and you're sitting there waiting for the listing broker to call you back and to send over your buyer broker compensation agreement, or excuse me, your brokerage firm compensation agreement. And you're sitting on the offer, and in the meantime, the property goes under contract because you're waiting to secure your compensation. That's a huge issue, potentially a breach of your fiduciary obligation to your buyer in that situation. But it's not how any of this should be working out. In that case, put it in 29.1 and send your offer over. But don't put it in both. That really conflates everything, and it's really going to force the seller to counter that offer, even if they wanted to accept every other term in it.
Yeah, and the other one I see is that they put it in 29.3, assuming they're going to get the brokerage firm compensation agreement. Now, keep in mind, the answer is that it's whichever is lower is what you get. So if you don't get the brokerage firm compensation agreement before you send in that offer, you could be working for zero. They send it over, say, here it is, it's zero. Well, now you got no agreement. You're working for nothing. And unless you turn around and then tell your buyer that they're going to have to pay the difference, you could have a problem there as well. So know which one you're going in. I'll tell you guys, I love 29.3 for a bunch of different reasons. And I know there's a lot of talk out there about just using 29.1, and that's fine. But, make sure you understand what that means from a buyer broker perspective. And even from a listing broker perspective is that, 29.1 is the seller paying it. It's not the listing broker. And the minute you have the seller that is paying that obligation, the seller might decide that there's reasons they shouldn't have to pay it. They might say, hey, I've been listening to all these ding-dong plaintiff lawyers that say that we shouldn't have to pay buyer broker compensation anymore, so I'm not going to pay it, and the buyer needs to pay it themselves. And if a title company says, hey, the seller's saying that they're not going to pay this, and we're going to escrow it because we want the deal to close, a couple things. First of all, the buyer broker can't interfere with the closing. You guys got to close that transaction. And number two, if they escrow it, you're now in a lawsuit with the seller. And if the seller moves to Nova Scotia, you're now in a lawsuit with the seller that you got to go find them in Nova Scotia to sue them. And so 29.1 has some pain to it because you're dealing with, if there's a dispute over that commission, you're now dealing with a seller that is long gone. And who knows what that escrow agreement is going to say, but there's a good chance it could say if they don't file a lawsuit within a certain amount of time, it goes back to the seller. So I just, I don't like that from the logistical standpoint. The other thing I want to point out is that, the beauty of our offer compensation in the MLS for years has been the fact that you guys have been able to avail yourself under the CAR arbitration process, which is a lot cheaper, a lot faster, and you're judged by a whole bunch of people in your business, which is different than you get with the court system. In the court system, you might get a magistrate that did family law that's looking at real estate going, I have no idea what this is. And they do the best that they can, but they aren't familiar with our industry. The arbitration process in CAR has just been absolutely fantastic. And unfortunately, we're losing a lot of that because we're losing procuring cause. However, brokerage firm to brokerage firm compensation agreements, that is still subject to the CAR arbitration process, which means that you still have that available for both a listing broker and a buyer's broker to any kind of disputes that come up as far as what should or shouldn't happen. And I expect we're going to see those things in arbitration, but it's going to be over agreements in email or agreements in text message or brokerage firm compensation agreement. So I like the brokerage firm compensation agreement from that perspective and using 29.3 because then it gives you a better venue for you to deal with any disputes that might come up.
Yeah, well, I do. I mean, one of the things I sort of manage in our association is the professional standards and in that case arbitration process. And I think it is an outstanding process for $450 filing fee. You know, you don't need legal representation. You're welcome to get it if you want. It's a very efficient, kind of smooth process, and it is a jury of your peers, so to speak. And so if you have 29.3 is the compensation box checked, and you have a compensation brokerage firm compensation agreement, again, the bar association's firm executed, or some other agreement between the two brokerage firms, then to Damien's point, you are eligible to participate in that arbitration process, which is going to be a lot more inexpensive, efficient. I think probably get it better in many scenarios than a civil court would if you had to go and deal with all of that. So, you know, I'm a big proponent of our arbitration process. I think it's fantastic, and that failure to pay on that agreement, if the listing broker didn't pay you per the terms of the agreement at closing, then you could submit it to arbitration, and that's a pretty efficient way to do it. But again, if you don't know, 29.1 is absolutely the way to go. And you know, again, we'll see how this plays out over the course of the next, you know, many months and years, because it will be interesting to see which boxes are checked and how. But in the vast majority of cases, you would never check both, unless it was a situation where truly the listing broker was going to pay you, you know, X%, and the buyer and the seller was agreeing to pay you something additional over and above that agreed X% and 29.3. You could have both. But if you're just doing both because you don't know which, stop doing that.
Yeah, the other thing I would like to point out, and I this is one I forgot to raise, Scott, with you, but you know, we have that buyer acknowledgement at the bottom of the form that says that how the buyer broker and the listing broker, or how the buyer broker is getting paid, is based on what is in paragraph 29. So I've had people say, well, do I have to put something in there? And you know, keep in mind that that's what's in there. And we also have a buyer listing contract that says that if you don't tell the buyer they owe money in 29.2, that you don't get to collect it. So using 29.2, even though we weren't talking about that, is another important aspect of this. I've had this come up with transaction coordinator fees and other fees that the buyer might be paying independent of the seller or listing broker. You know, between the acknowledgements at the bottom of the contract and the form that says that you can't receive more than what you've told the buyer about in writing before they sign a contract, 29.2 is also a very important box for those extra fees or anything else that you have. So sorry, I meant to put that on there, Scott, but I forgot. So
no, agree with everything you're saying. Now, are the broker acknowledgements, is that a part of the contract, Damien, or is that? I'm kidding. I couldn't resist.
Nice. Yeah, I don't know. I forget.
It's right below that big bold all caps thing that says this is the end of the contract.
Yes, that's the one. Yeah.
So it's not a part of the contract.
And it's not a compensation agreement. I know that's hard to believe, but
it's not.
There you go. Okay, another one. Do I have to show property that is not offering compensation? And this, I tell you, this came up with some of the state forms that were being created. You know, Scott, you remember the DOJ weighed in on a couple of those things. You want to start this, and then I'll.
Yeah, well, I mean, the answer is absolutely. You've got to make your buyers aware of properties that aren't. I mean, when you have a brokerage relationship with a buyer, your job isn't to look at your own interests first and to filter properties by is there compensation or not. For years, the MLSs have not been allowing you to filter by compensation, and now obviously all that's out the window anyhow. And so the concerns related to steering are, I would say, among the highest future antitrust potential issues that I could see our industry needing to be worried about. Steering is, we know the DOJ is looking at it. We know that the plaintiffs' lawyers are obsessed with it. We knew that new lawyers might be obsessed with it, that might see some of the low-hanging fruit or dollars that are hanging off of the real estate brokerage tree in terms of some of these settlements and lawsuit values. So we've been absolved of our sins as an industry up through August 17th of 2024. Beginning August 18th, 2024, it's a new day. And so to the extent that we're doing activities, including steering with our clients, we subject ourselves to potentially Division of Real Estate license law violations, absolutely, for breach of fiduciary, breach of uniform duties, as well as, to the extent that it's being done in any way collectively as an industry, all of the antitrust concerns that have already been enumerated. But I think there's maybe some caveats that you want to talk a little bit about, Damien, with regard to that.
Yeah, I mean, I agree with everything you're saying. I mean, the problem here, so what happened is there was a couple of states that started drafting forms, and one of the things they started drafting into their forms was a blanket provision that essentially said that the buyer is instructing the broker not to show them properties unless it's offering compensation. And it was framed in a manner that the buyer was now instructing the broker to do this based on the, and guys, there's real reasons that a buyer may not want to have a broker showing properties. I mean, you can imagine a buyer who says, look, I can qualify up to $500,000. I have $100,000 of down payment for my 80/20 mortgage. I got nothing left. There is no more money in there to pay you, broker. I'm maxed out. So there is no way I want to go look at a house that isn't offering compensation and take the risk that I'm going to fall in love with the house and there's no way for me to purchase it. One of the things that comes up that I want to point out is that, for every dollar that the buyer broker has to, or that the buyer has to pay their buyer broker, is the equivalent of $4 to $9 of mortgage that they cannot get. And that's based simply on a 5% loan, a 10% loan, or a 20% loan. So if you got an 80/20 loan and $100,000 down, then you get a $400,000 mortgage. But if they got to pay $5,000 to their broker, then that's essentially $20,000 that the loan gets reduced. And it's important that sellers understand this. That's why we started that conversation with the seller understanding the impacts of not offering compensation. And so you could totally see a buyer saying, look, and I've actually already had this a couple of times where the broker's like, my buyer doesn't want to go look at this property. Am I steering now? And the answer is no, you're not steering. Buyers are allowed to steer themselves all they want. And if you say, hey, I got 5 properties that meet your needs, 3 of them are offering to pay my compensation, these other 2 aren't, and the buyer says, well, I want to go look at the 3 first and see if I fall in love with one of them, because I really don't want to go fall in love with one that I'm not going to be able to afford. They are free to do that, guys. And that is not steering. Now, the blanket clauses don't work because to me, as Scott's been saying, is you have a duty to at least tell your buyer about it. But if you tell your buyer, hey, we got 5 properties, these 2 are not offering compensation, which means that if they don't pay it, we could ask for it. We can certainly put it in 29.1. We could say, hey, we want you to pay this. But if they don't pay it, you would have to come up with the difference. And the buyer says, then I don't want to look at them. That's not steering, guys. That's buyers allowed to do that. And again, that's where I think the seller needs to be aware that that may start happening in our industry because of this buyer obligation now.
Yeah, well, so to that point, the analogy I've been using when we've had questions about it is this. Historically, for you guys that work with buyers, that a good buyer, they're going to tell you as a broker, like, listen, I'm qualified to $750,000 purchase price, and that's it. Don't show me $800,000 homes. Don't show me $760,000 homes. Show me up to what I'm qualified for. The other stuff is only going to distract me. And it's a very similar analogy. If buyer's trying to hamstring together dollars so that they can pay their broker, that it's coming out of someplace that's going to have an impact on what they can look at. But moreover, they're going to self-select in some cases. At least I think good buyers will, to say, I'm only going to be distracted because even though I've signed this agreement with you, I'm not willing, I'm not able, I can't cut a check to you. So if the property's not going to compensate you either through the seller or through the listing broker, then don't distract me with that opportunity. And to the extent that that's what's going on, I couldn't agree more. Buyers are free to pick and choose and select and steer themselves all they want. Just don't let that be a component of something that you're doing on behalf of your buyer, because that creates all kinds of additional problems.
Yeah, agreed. Okay, can I require the buyer broker show me their buyer listing contract?
If the listing broker asks you to see the buyer listing contract to confirm the percentage that the buyer is obligated to compensate you, I would encourage you to ask the listing broker to see a copy of their exclusive right to sell listing contract to confirm that that percentage is sufficient to sign the buyer broker compensation agreement. I'm kidding, of course. The answer to both of those is no. Those are, first of all, I mean, just from a confidential agreement standpoint, that if you ask the Division of Real Estate, what they're going to say is those are confidential agreements between the buyer and the buyer broker, and or the seller and the seller broker. And our industry has never, for all of the years of having listing brokers advertise compensation on the MLS in a certain percentage of form, have buyer brokers been picking up the phone going like, hey, I see you're offering X%. Could you just send me a copy of your listing agreement to confirm that you're authorized to offer X%? It's the same kind of nonsense. If a buyer broker, is requesting more than what their buyer is obligated to compensate them, they're in violation of their MLS rules. They're in violation, I would argue, of state law, because you got to remember now the exclusive right to exclusive right to buy, as well as the buyer broker compensation agreement, the one that's at the bottom of the broker disclosure to buyer. Both of those have language in them that say the broker can't accept more than what the buyer is obligated to pay them. And so on some level, our industry has to understand that we don't need to police each other. There's procedures, Division of Real Estate and MLS policy in place to handle some of that policing. So I think it is inappropriate to be asking a buyer broker to provide a copy of their compensation or their brokerage agreement or compensation agreement. Again, those are confidential documents between the buyer and the buyer broker.
Yeah, and giving the listing broker the benefit of the doubt that the reason they're asking is because they don't want the seller to have to pay too much. That means that you need to set the offer of compensation somewhere else. I mean, if you're that worried that they're going to pay more than what they need to, then again, it's a conversation with your seller about how much do you want to offer that you can live with. Because if the buyer broker is getting less than what the seller is offering and they use it for seller concessions or something else, the seller should be comfortable with the net, because you should have already had that conversation with them. Like I said before, the offer of compensation that the seller has instructed you to offer is the amount that the seller is willing to do in order to encourage those offers to come in. And they got to be comfortable with that, regardless of how that money gets used, whether it's for the buyer broker paying that obligation, or it's in seller concessions, or the buyer broker amends their listing contract. They just got to be comfortable with that. And that's the conversation that should be held ahead of time instead of worrying about this stuff later. All right. Okay, my favorite. You ready? Does Colorado have a touring agreement? And when does it have to be signed?
Well, yes, we have something. We have two things that would work as a touring agreement in terms of documents that are available for your use. One would be obviously the exclusive right to buy. That's an agreement that's signed between the buyer and the buyer broker, and that would check all of the boxes, all of the requirements of the MLS policy related to a touring agreement. And then, of course, the buyer's broker compensation agreement, which is the bottom of the broker disclosure to buyer. That as well checks all of the boxes. It's just that's executed. So either one of those. So the answer is yes, we do. The gray areas, to some degree, have been created by, I think, the perspective of the Division of Real Estate. I think they just candidly don't really like that piece of the settlement agreement. And the fact that in Colorado, our commission rule, or I should say our license law, while we require a broker to obtain a listing broker, seller listing broker, to obtain a written agreement with a seller prior to performing brokerage services, you got to have an exclusive right to sell. We don't in Colorado require the same thing of a buyer to perform buyer broker services. You could default into being a transaction broker for a buyer through the delivery of a disclosure, which is not an agreement. And so that state law perspective in conflict with the practice changes or the settlement agreement that all of your MLSs have entered into with the plaintiffs in order to settle the dispute here, which requires a written buyer agreement. And so this has been probably the single most misunderstood. And the problem is it's just a really difficult answer. If you were to ask NAR on their interpretation of MLS policy, there's no question whatsoever that they would tell you that it is required to have a written touring agreement with a buyer prior to showing or touring properties. If a consumer is to ask the Division of Real Estate, do I have to sign a written agreement before I can tour properties? Their answer is going to be absolutely not. Okay. And so therein lies the inherent conflict. Your MLS policy in the vast majority of the state is going to require that you have that written touring agreement. And an analogy here is the clear cooperation policy. You could call the Division of Real Estate for years now. It's been around for 5-6 years now, and say, hey, this listing broker has a coming soon sign in the front yard for the last 2 months. And they're going to say, we don't care as long as the seller's on board with that. In other words, as long as the broker's not doing that exclusively for their own purposes and the seller is authorizing that and understands the implications of that, that's no problem. But if you call the MLS, they'd say, well, that's an absolute, no question, a violation of the clear cooperation policy. So this is a situation where there are additional rule overlays being implemented by the MLSs, just like clear cooperation has been for years. In this case, the written buyer touring agreement. So I don't know. That's my
I saw there's some confusion real quick about what a touring agreement is, guys. A touring agreement is essentially what has been referred to in the NAR settlement as the agreement between the buyer and the broker who is taking somebody to look at property, to show property. That's what the touring agreement is. As far as Colorado is concerned, our touring agreements for purposes of the NAR settlement are, like Scott said, the broker disclosure to buyer with the compensation agreement at the back of it, as well as the buyer listing contract. Those are the two forms that meet those needs, and you can use those to do them. I will tell you, there's some pain points with those agreements. Namely, I've heard people say, well, I'm going to do, and I think you've heard this nationally when you hear conversations with, there's things like Zillow creative form, which incidentally, guys, you're not allowed to use. EXP creative form, they're not allowed to use that one either, because we have very strict rules about what forms are allowed in Colorado. And your two forms are the BD24, or the broker disclosure to buyer, and the buyer listing contract. That's it. That's the only two you get to use for this purpose. But I've also heard people saying, well, what I'm going to do, since I'm just going to go show them property to make sure I'm complying with the MLS requirement, is I'm just going to put 0 in the box, and then I'm going to go show them property. Well, does that work, Scott? Can you just put 0 in there and have it work?
Absolutely, 100%. But what are you going to collect, or what if you have 0 in that box? Then what are you allowed to request from the seller or listing broker? What are you allowed to receive or collect at the closing? 0.
Yeah, and my pain point is this: is they think, well, we'll put 0 and then we'll renegotiate before we make an offer, and we'll have the buyer sign a different agreement, like a buyer listing contract, or do a different compensation agreement. What I want to warn you guys is the way Colorado law works is that once you've established that working relationship, which we're going to talk a little bit more when we get to open houses here in a second, but once you establish that working relationship with that buyer, you now owe them duties. And that BD24 establishes that you're acting as transaction broker and you owe them duties. And if you put 0 in there, and then the buyer says, well, I want to buy this house, and you say, okay, can we sign an agreement so I can negotiate my commission, or I can make sure I can take a commission? And they say, wait a minute, I don't want to be obligated to pay you anything. I think you have an obligation to write the contract for that client for 0. Don't you, Scott?
Yeah, I mean, that's all. I don't see in a way you can ask for anything more than 0 based on all of the practice changes that have been implemented. It's very clear. You are only able to receive, accept, request up to whatever the buyer is obligated to pay you. And if 0 is the number, 0 is the number. And there is nobody out of the, 300 and whatever, almost 70 people that are on this call and will be watching later, that are worth 0 for your professional services. And when you decide that that's your perspective, I think, that will be the tipping point for survival versus thrival. Is thrival a word? Surviving versus thriving.
I like thrival. Thrival works.
Survival versus thrival. Surviving versus thriving, which I think is where maybe some of the opportunity lies for people who get this stuff right.
Yeah, I'm gonna try and power through, because I got 2 more I really want to get through before we start answering questions, because you and I have talked about what the most frequent questions are that we hear. But the biggest one is about open houses. How do you do open houses with this new touring thing? And this is complicated, guys. I'm going to tell you, this gets complicated because of around our license laws, what you can and can't do. I mean, one of them's easy, but Scott, go ahead and start on this, on open houses.
Well, so open houses, nothing's changed in my perspective on open houses on a fundamental, essential element, and that is, for years, if you're a listing broker and you're holding an open house on a weekend, and you're unrepresented consumers, buyers are walking in, having a look around, I think you need to be prepared in very reasonably quick order to present them with a broker disclosure to buyer, which in this case is going to say, hey, I'm the seller's agent, probably, maybe TB. You're a customer as we stand here on the porch today, or in the living room today. And that's been required by the Division of Real Estate. It still is. And I think the standard, or the timing of that, is before eliciting or receiving any confidential information from a buyer. But confidential information is a pretty low bar. I mean, when that buyer, the example I always use, tells you, "Hey, I love your property, but it's listed at $900,000. We're only qualified to $750,000." Guess what you've just received or elicited through no fault of your own, because you're also darn charming that that buyers just want to tell you things, right? So it's a low entry point to get to that place where the DRE and the real estate commission is going to say you absolutely need to be disclosing your brokerage relationship to that unrepresented consumer. And that hasn't changed. And I think you need to start there. I'll let you talk about what you think, Damien, has changed in connection with all of this.
Yeah, I mean, so yeah, I agree. The listing broker is easy because you don't need a compensation agreement. You just need to disclose their customer. You need to show property. That's your fiduciary duty to your client. Where open houses get confusing is when you're doing an open house for somebody else. In other words, it's not your listing. You don't have a relationship with the seller. That gets problematic because as Scott pointed out, Rule 6.5, because I'm a geek, says that you must disclose working relationships to the buyer before you elicit confidential information. And so if you're in an open house for somebody and somebody comes in unrepresented and they're looking at properties, if you start getting confidential information, then you have to give them the broker's disclosure to buyer pretty quickly because you're eliciting confidential information. And now you're establishing yourself as that transaction broker, like we talked about. And now you're going to have a compensation agreement if you want to get paid should the buyer want to buy that property at the open house. So from what I can see, there's two perspectives on how to do it. You could have the buyers come in and say, look, and say, look, if you want to talk to me about what you can qualify for, or what you're looking for, happy to do that, but I got to do this, and you got to sign a compensation agreement. Or you got to tell them, don't talk to me. Don't tell me what you can buy it for. Don't tell me what your motivations are. Don't tell me, what you're looking for or when you're coming or your time frame or any of that, because now you're getting those motivating factors, which are confidential. And it's a fine line there. I've heard different people thinking that, well, if they have the brokerage firm compensation agreement ahead of time when they're doing the open house for the listing broker, that at least they can show the buyer, look, I need to have you sign something that says you're obligated, but if you buy this house, I want to let you know that the listing brokerage firm has already agreed to pay my compensation. And that's not a bad approach. And I think that works fairly well, but you got to be mindful of that because if you're doing open houses trying to get buyers and buyers aren't going to sign your compensation agreements, you may end up working for free on a lot of different properties. And so it is where it gets difficult is when you're working for somebody else's open house, when you're holding somebody else's property open. That's where I see it. Anything to add, Scott?
No, you're exactly right. In that situation, you're a door opener because you don't have a brokerage relationship with the seller. And so you have nothing to disclose exactly to the buyer, except to create then a transaction brokerage relationship with that new buyer. And I think you got to be careful. And if you're going to allow other people to set your open houses for you as a listing broker, you got to be careful that person's not running buyers off, right? Because think about buyers who might be coming into an open house and somebody's kind of saying, hey, it's not my property, but I need you to sign this, or I need to disclose this brokerage relationship. And the buyer's like, I just want to be left alone, but I'm out of here, kind of thing. Like, you got to be very clear on what delineating the rules here. And if you want to be a door opener, that's fine. You could do anything in that house in terms of like opening doors and making sure nobody steals anything or breaks anything. When I was a kid, I was probably 15 years old. My mother has been a realtor for many years, but she used to pay me like $10 an hour, which at the time was, a lot of money to sit on her open houses sometimes. But her instructions were always like, you can't do anything, Scott. Just open the door, make sure they don't steal anything because you're not licensed. In this context, if you don't have a brokerage relationship with either the seller or the buyer, you, even though you are licensed, are essentially as good as being unlicensed for the purposes of anything you can do. So you got to be mindful of that and cross that hurdle as appropriately as you possibly can as you're dealing with that unrepresented buyer who you don't have a brokerage relationship with.
Yeah. And then if you're going to cross that line, you're going to have to get your broker's disclosure to buyer, and you're probably going to have to get a compensation agreement signed if you want to get paid if they decide to buy that property. So that one's a little tougher.
Yeah.
So, and frankly, if they're not offering compensation, do you really want to sit, if there's no brokerage firm compensation agreement, do you want to sit in an open house where you got to tell buyers that come in, they have to sign something that obligates them to pay you, where you don't know if the seller's going to pay it or not?
Yeah.
Consider.
It's difficult.
Yeah. Okay, last one, and then we'll get into some of the questions, guys. And this is about buyer listing contracts and limiting the buyer listing contracts. I know you have one on commissions. Why don't you talk about that as far as, different commissions in the buyer listing contract?
I'm looking at the outline. I'm trying to remember what was my one on commissions.
I think you said for one property it was this, and one property it was this.
Oh, yeah. So in a buyer listing contract, yeah, this has been actually, I have had a number of these calls as well, where maybe in some situations a buyer broker is going to start working with a buyer, and the buyer thinks they've already found a property, and they want to essentially have you agree to compensation that might be lower for that property, but they're willing to consider some other properties, and so they're willing to have something that's higher for every other property. And so what the question has been essentially is that, are you allowed to do that in your exclusive right to buy or on the buyer broker compensation agreement? Because remember, you can't have variable commissions. They need to be objectively ascertainable in order to be compliant with the settlement agreement and all that other stuff. And so I think that would be, though, let's say that, you enter into an agreement with buyer that says, buyer, if you purchase 123 Elm Street, then the compensation that I will receive, or that you're going to be obligated to pay me, is going to be X. If you purchase any other property, compensation is going to be Y. I don't think that's a variable commission at all. You're being objectively ascertainable for two different properties, or two different categories of property, one identified property and the other not identified. And so I've had a few of those calls, and for whatever reason, the buyer is asking to be obligated to pay less money on usually a pre-identified one or two properties, and they're willing to consider other properties. And that's kind of what I was getting at there.
Yeah, and the other one I see a lot is that you have the buyer who says, well, I want to work with you in Aspen, but I want to work with somebody else in Telluride or something along those lines. And the question becomes, can you limit the geography in the buyer listing contract? And I think most brokers know you can limit the geography, but what I end up seeing is that the way they limit the geography is they put in paragraph 3.4 of the buyer listing contract. That's the provision that says property, and says the following property identified by buyer, and then you guys write in 3-bedroom, 2-bath, or whatever. The important thing to remember is that 3.4 is not a limitation on geography or the property that you're looking for them. That is a limitation on what the broker is looking for the buyer. Because what it actually says, it says the following property or otherwise acceptable by buyer, which means that property is anything the buyer buys in the state of Colorado, regardless of what is in the parameters of 3.4. So if you are limiting the geography of a buyer listing contract, it really needs to be done in additional provisions that says this buyer listing contract is only for any properties located within the town of Castle Rock, or whatever it happens to be. And that's where you have to limit it geographically, not in paragraph 3.4. But you can limit those listing contracts based on what your buyer is looking for. And that might make it easier to get those things signed when a buyer is saying, well, I'm not sure where in Colorado I want to be, but I would work with you if it's in Breckenridge. Then, you certainly could do that. Scott, anything to add?
No, agreed. That's always been the case with the agreements, but I think it's a commonly misunderstood piece of how the exclusive right agreement works. So good point.
All right, so that got through most of the ones that I had. And Scott, you have any others that you thought of while we were doing this, or should we jump into questions?
No, we better jump in. It looks like there's a laundry list of questions there. So let's just try and answer them raw as they come.
All
Okay,
right,
so
you're
we've
on.
got 55 questions. Do me a favor, guys, and go into Q&A and upvote your favorite questions. So we'll try to get to the questions that most of you are most interested in. So we'll start with Stacy's question. If a broker asks what the seller compensation is offered and the listing agent thinks it will hurt their seller, are they required to disclose the amount no matter what it is?
I mean, I'll take that one. Again, that's not a question that that's not an issue you should be questioning. In other words, if your seller thinks it's going to hurt them, then just have them put NA or 0 in 7111 and tell any broker to put it in the offer and leave it at that. I don't want to believe that listing brokers are making determinations about what's going to hurt or harm their seller and essentially be pushing away potential buyers or buyer brokers on that basis when they have a pre-negotiated agreement with their seller agreeing to X% whatever dollar amount in 7111. I just can't see another way to analyze that question.
Yeah, and I'll tell you, I actually think thinking it hurts your seller is you deciding for your seller something that is contrary to what your seller has instructed you to do. I think it's a breach of your duties. In 7111, they've told you to advertise this amount. And if there's some question about whether it's going to hurt your seller, then you need to go back to your seller and talk about if they're sure that's what they want to offer in 7111. But once you have that in 7111, that should be automatic. Yes, this is what they're offering. Yes, this is what they're offering. Yes, this is what they're offering. Sending brokers from compensation agreements, send them out all the time. Because again, like I said, 7111 is about generating offers. And the seller has said, I want to pay a portion of the buyer's obligation to their broker in order to generate those offers. And when you're playing hide the ball and not telling them all that you're going to offer, you're not going to generate that offer potentially, because the buyer might say, if they're not going to tell us, then I'm going somewhere else. And in a strong buyer's market, you may have actually just hurt your seller instead of helping them.
Okay, if I do not renew my realtor status, am I no longer protected under the NAR settlement against future lawsuits from past transactions?
I'll answer that question.
Want me to take
well.
this or?
Well, no, I don't. I mean, I don't mind. The candid answer is this: the NAR settlement, as I said, for everybody, has been absolved of your antitrust sins in the real estate industry as of August 17th, 2024. That's the hinge point date, and that's the reason all these practice changes had to go into effect by August 17th. And so, as long as you were a realtor on August 17th, you have protections from the implications of anything having to do with these lawsuits. And assuming you were not in a couple of very narrow exceptions, I should say. But the bottom line is this: yeah, you've got your protection as it is, and your protection is not contingent upon ongoing or continuing membership in the Realtor Association.
And guys, I'm going to go a step further on this because I know Scott won't do it. A plug for the association. I got to tell you, my concern about people dropping membership is you got to remember those dues go for something more than just your locals and you know, the supporting the local associations and those kind of things. The biggest thing that our Association of Realtors has done for years and years is protect property rights of not only your clients, but also you guys. And one only needs to look at what happened in the pandemic to see what CAR did for you guys to make sure that you were essential employees. And so if you are thinking about giving up your membership, I just want to warn you that that could come with a consequence. If a lot of people give up their memberships, then that makes the lobbying efforts much weaker. And it means that our industry might be subject to a lot of the goofiness that's going on both at the state and federal levels. You know, you heard that there was an announcement that the federal level was thinking about putting in place rent controls, national rent controls. You've heard about 1031 exchanges being attacked. You've heard about the mortgage interest deduction being attacked. And but for the efforts, largely in part due to NAR at the federal level, we've beaten that back, or they've beaten that back. So I get it. I understand, you know, both from an economic standpoint, as well as, let's face it, NAR's had some black eyes here recently. But, you know, don't throw the baby out with the bathwater on some of that stuff. That's all I'm going to add to that.
Yeah, and I mean, you say I won't do it. I mean, I advocate for our association and membership all the time, and I will happily say this: there is no better advocate for your interest in your communities, in your counties, in your local areas than your local association of realtors for your professional interest. There's no better advocate, and at the state level, I can tell you, there's no better advocate for your interest as a broker, licensed broker in Colorado, than the Colorado Association of Realtors. And at the national level, there's no better advocate than the National Association of Realtors in the United States Congress or anywhere else. Among any business trade organizations, I would argue that NAR and within the state, CAR, are two of the most impactful business lobbies, business trade association lobbies of any place in the country. And CAR, any other business lobby for any type of business in the state. So I have no problem saying it, but you know, it's that question that people are like, well, they got us through this and we got us coverage, and now we're going to take off and go do something else. I mean, I on some level sort of, I understand the question, but I resent it, and I resent having to answer it because I know everything that is done by the realtor associations on all three of those levels. If they go away, I can promise you this. There's some new association nationally of a bunch of clowns that are, former TV realtors or whatever they were. There's 100 and some years, 120 some years, I think, of history of NAR, who is without question the most powerful voice, one of the top 5 probably most powerful voices in the entire Washington D.C. With regard to our interest. And anyhow, I'll leave it there.
Okay, he is going to say something.
Okay, here's a question. I gave up on trying to get new buyers to sign a buyer agreement just to look at one house. I'll make them sign the buyer agreement before I present an offer. Am I in trouble?
That's a great question. And in Colorado, I have no idea what the answer is. The problem's going to be you have a duty, you are now acting as TV, and if they refuse to sign something later, then technically, they could say no and you owe them duties and you have to write an offer. I mean, this has been a gray area because I think we're getting conflicting messages from both NAR as well as from the Division of Real Estate as to what's required and what's not required in Colorado. But Scott, why don't you, I know how much you love elaborating on this, but I think you better.
No, I'll just say this. I mean, the question is appropriately poised for your MLS. That's ultimately who's going to determine if you're in trouble for not having a touring agreement. And I'm going to emphasize this again and again and again. If you are ever having a conversation with a buyer in Colorado and a consumer and basically saying, hey, I need you to sign this agreement because it's a requirement, to the extent that you are saying or leaving them under the impression that this is a state of Colorado requirement, commission requirement, Division of Real Estate requirement, license law requirement, whatever, you are making a misrepresentation of that consumer. And I can tell you right now, the Division of Real Estate is drooling to ring a few brokers up and they've already had complaints from buyers specifically on this issue. And they're gonna discipline them because that is a misrepresentation. This is an MLS policy, an MLS requirement, not just for realtors, it's for any MLS participant through the MLS policy. So if you're in trouble, to answer the question more directly, that's a question for your MLS. What are their policies with regard to discipline, fines, suspension, expulsion from MLS participation if you're not adhering to the MLS participation rules that you're expected to abide by?
Okay, next question. I put in an offer for my buyer and asked for a certain percentage for my compensation, but it was more than what the listing agent told me verbally over the phone. She called me after I put in the offer and yelled at me for asking for a different, higher percentage. I feel I was right to negotiate on my buyer's behalf. Who is right?
Well, it doesn't matter. I mean, what I'm having trouble with this question is my bigger question is what was in the buyer listing contract? And if the higher amount was in the buyer listing contract that the buyer had the obligation, I have no problem with a buyer broker negotiating more than what the brokerage firm compensation agreement says. That's that you're trying to get the most for your buyer as far as contribution from the seller and or the listing broker. Now, I think if you're putting in as a brokerage firm compensation more than what your agreement says, then you're making a mistake because it's going to be the lower amount. But there's certainly nothing wrong with putting in 29.3, the amount that they're offering as brokerage firm compensation, and then adding to it under 29.1 saying, hey, seller, I want you to make up the difference for my buyer. That is totally fine. And if the seller says, I'm not making up all the difference, but I'll do part of it, putting in another amount into 29.2 is fine. You can use all 3 boxes. So I don't know why the listing broker was upset. I mean, at the end of the day, they told you what the amount was and they gave you an amount, but if it's not enough to clear the buyer's obligation and the buyer instructs you to try and get all of it for them, you absolutely can do that.
Totally agree.
Okay, next question. 711 total compensation paid by seller. 7111 sellers doesn't offer anything here and checks NA. Now the seller receives an offer with 29.1 checked with a number. Does this number come off the number that is on 711, meaning the seller's broker's compensation now will be reduced by this number, even though the 7111 is marked NA?
Can I answer this one, Damien?
Go ahead.
It gives me an opportunity to compliment you because what this invokes then is 7112, so just below 7111. that clause, I've been saying this, and I believe it's the most artfully written clause out of all the changes that were made throughout all the contracts and the broker compensation agreement, brokerage firm compensation, all of it. I think 7112 to me is what really strikes me, and I'm going to compliment Damien because he's primarily responsible for crafting that. And I've said this, I say this to him. I don't compliment him often, but I think he's the finest writer of contract language. He doesn't write well like otherwise, but contract language he's really, really good. Unless
His
you
love
get nice
letters are terrible, Scott.
Yeah, thank you, Joe. I was going to ask, do you get nice love letters? No, he's totally inarticulate, but when it comes to writing a contract clause, the guy is magical. I'll give him that. I'm just kidding, of course. The 7112 controls here. And so what that 7112 effectively says is if you've got in 711 your total compensation of X and you have 0 in there, then what it means is if the seller accepts a contract in 29.1, it will be what 7112 says is that it will reduce the total compensation 711 by up to the amount that's listed in 7111. And so in that case, 7111 says 0 or NA, meaning that it would reduce the total compensation in your question or your example by 0. So you don't have to worry about it. And it's the reason I like it so much is because it protects the seller from getting into a situation where they accept a contract and then somehow end up trying to have to pay double commissions to their own listing broker and then maybe something else to the buyer broker. And it protects the listing broker from having their total compensation dipped into by the seller accepting some offer that obligated the listing broker to lose some money. It works really pretty perfectly. I really do love 722. Look, Damien's blushing now.
Yeah.
Okay, next question. What if the seller has within the listing agreement agreed to pay a buyer's agent and then gets multiple offers and decides he now does not want to pay as much? Can he instruct you via an amend of the listing agreement to change the amount and tell the buyer's agents that submitted the offers? In other words, compensation among the multiple offers is now based on compensation, which could inevitably put more net in the seller's pocket.
So I'll tell you, this is why I feel like it's so important that we have the brokerage firm compensation agreement, is because the seller and the brokerage firm are agreeing as to how much is going to be offered to buyer brokerage firms. And I'll tell you, you could amend the listing contract and you could change the amount and you could, tell the other brokers, hey, they're not offering as much and you got to change your contract and lower the amount. You certainly could do that. But, you got to remember, I would tell the seller, look, the reason we're getting multiple offers is because we made this offer of compensation, because we offered this to the buyers, and the listing broker doesn't have to agree to amend that. That's not something you have to give the seller if you feel like it's going to harm you, not only with the negotiations of the contracts, but also within the industry because you made this offer to people and now it's being changed. And so my suggestion would be to tell the seller, instead of worrying about what we're offering the buyer broker and trying to harm, decrease the buyer's bargaining power by making them pay something back to their buyer broker, let's raise the price. Let's take these multiple offers and push the purchase price up, and let's make your net more that way by negotiating instead of playing games with the buyer broker's compensation. And like I said, it's in an agreement so that you don't have to agree to change that for the seller because they say that's what they want to do. And my perspective would be, you're better off saying, look, let's leave it alone because we got all these offers we're working for. This gives us an opportunity to pit them against each other and to bid this up and go counter at a higher amount. And let's get a better net for you that way instead of decreasing the buyer's purchase power. Scott, you have anything?
No, I mean, I agree with what the principle of what you're saying. I guess maybe the question though, I mean, I'll say it this way. Unlike the MLS old offered compensation that we've had for as long as anybody's been in the business, the rule there is that once an offer was submitted, the listing broker was not able to modify the offer of compensation once an offer was submitted. And that is no longer the case. So in a technical sense, as long as your seller hasn't accepted an offer that has something in 29.1 or something in 29.3 in connection with you having also executed a brokerage firm compensation agreement, then the seller is going to have to review those offers, and maybe that might change. And if you've already accepted a brokerage firm compensation agreement, or I should say, if you've already given a brokerage firm compensation or agreed in that to give a buyer broker something, the language in the buyer brokerage compensation agreement would, as it's been recently updated, address that issue. And as long as you were making sure that whatever was in 29.3 was accurate with regard to what the seller was still now agreeing to pay, then you wouldn't have to amend anything, because the the brokerage firm compensation agreement, the bar association form, it says it's going to be the lesser of the two amounts. And so
I still think you'd have to probably amend the listing well, I don't know. That's interesting, because I think I'd want, as a listing broker, to amend the listing contract to the lower amount to show that I did what the seller instructed me to do. That would be the one thing I would say.
No, I don't. I guess I'm not disagreeing with that, but I'm saying you wouldn't have to counter or amend the offer, or the offer. Your seller could accept that offer. I mean, listen, we still, have to be in an industry and work with each other. So I don't like the behavior. I like your answer, Damien, but I was just trying to get to the point that the other reason, or one of the reasons I think we both really like the Bar Association's form, is that it really was well thought and contemplates a lot of protections really for both parties. But in this specific example, from a listing broker having signed an agreement for more money and then having something change for whatever reason, and as long as the lower amount then is in the actual contract in 29.3 that's accepted, that listing broker is only going to be obligated to compensate the lower amount. And so anyhow, I mean, listen, we all play in the same sandbox. And so it's not like you want to, I mean, I think I can make arguments about bad faith and unfair dealing and all these other concepts. If you're allowing your seller to allow you or instruct you to dangle out some offer of compensation and then kind of pull that away. But it's not like the old MLS was, where, just present an offer and you had secured, at least locked in that percentage that had been offered.
If I have an open house and a potential buyer comes with a friend or family member and shows interest in the home, I know I need to provide a document for signatures, but who needs to sign? Both husband and wife? What about the bank of dad who is coming with his child?
Are you going to take that one, or you want me? Whoever's going to be your client.
Yeah, that's just, you need whoever's going to be your client to sign it. And I don't think you have to have everybody sign it. You just have to have somebody that you're showing the property to that's going to be your client has to sign it.
Yeah. Whoever you're going to enter into a brokerage relationship with, that's the bottom line. That's
okay. Since the seller is negotiating with the buyer for the buyer agent compensation, can I, as the listing agent, state in the private remarks in the MLS with respect to section 29 in the Colorado contract to buy and sell, select 29.1 and fill out accordingly, as this is a negotiation between the buyer and the seller? I think that in the long run, it seems more advantageous to potential brokerage firm liability to remove my brokerage firm from all issues pertaining to the buyer brokerage compensation. Am I way off on this thinking?
I think it depends on the market. I mean, if you're doing 29.1, first of all, I don't know if the MLSs will even allow that, and I'll let Scott address that.
Yeah, I'd say ask your MLS, because that's ultimately who's going to be the arbiter of that question.
But again, you're saying put the amount in. You're not giving them a contract that says how much you're paying. You're not enticing them to make an offer. And you're essentially saying the seller is going to look at your offer and decide whether they're willing to accept the amount or not. And I think, Karen, that creates in a buyer's market that could be disadvantage your seller, because you're saying put it in and you'll negotiate it, whereas everybody else over here has it for X. I could see buyers self-selecting to go look at the properties that are offering X and making offers on them instead. So for me, I don't think it's a decision that a brokerage firm should make unilaterally for a seller. I think it's a conversation they should have with the seller and let the seller decide. And if the seller decides, no, I want to negotiate it on a per contract basis, then fine. But I have a hard time with the hard line. As a brokerage firm, we're going to do it this way because of our liability, because I think it could disadvantage a seller, but that's just my 2 cents.
Okay, so here's the scenario. I am the listing agent. An unrepresented buyer wants to see the property. I want to just represent my seller and treat the buyer as a customer. Is a BD 24 indicating the buyer is being treated as a customer sufficient?
Yep, just like it always was. You would only use the BD, you'd only use the compensation agreement at the end of the BD 24 if you're entering into a transaction brokerage relationship and you're expecting the buyer to compensate you. So you can ignore that whole portion, just like you always have. If you're the listing broker, you're going to treat you're the seller's agent. You're going to treat the buyer as a customer. Just use the normal old section of that to disclose that. Disclose to the buyer they're going to be a customer and that you have no duties to them, and move along. And let me actually say, this is something I've been really hammering on too. And I don't know if you and I have even talked about this, Damien, but I'm curious to hear your thoughts. I've had a ton of questions recently because I think you guys are seeing a lot more direct buyers coming to you directly saying, I'm not represented, whatever. First of all, I love the listing broker, the seller's broker, and I know you agree with me on this, that is willing to hang in there and say, hey, I'm the agent for the seller. I'm going to treat you as a customer. You don't want to have representation. That's no problem for me, but I'm going to remain the seller's agent. I love that relationship, as probably anybody listening to me here knows. But that creates a problem in the situation where you're seller's agent and buyer's unrepresented, because the buyer's like, well, I don't know how we use the forms. I don't know what these dates and deadlines. I don't know. This is complicated contract. I can't write it. Can you write it, listing broker? The answer, of course, is yes, because you're allowed to perform ministerial duties on behalf of the buyer. Really, it's for the benefit of your seller, right? You're moving the contract forward. But here's what I believe is a great way to do this. If you've appropriately disclosed that the buyer is customer, you go back to your seller and say, hey, seller, look at here. We've got a great opportunity. You and I, seller, are going to write up the greatest contract in the world. Sit down with your seller, write up the most fantastic offer you could possibly write up, perfect dates and deadlines, purchase price, closing time frame, possession terms, all of the stuff. Fill it out, have your seller sign it, and allow your seller to make an offer to the buyer. And then you're just presenting that offer to a buyer, and you're not trying to write an entire contract. And if they want to accept it, great, they can accept it. If they want to counter it, then at least all you're really having to talk them through or perform ministerial duties with them on is a counter proposal, which is a lot easier than trying to do it on an entire contract. So those are my thoughts. And I'm glad the question came up because I've really been harping on this recently as I've been talking to people. Damien, any thoughts on that?
I think that's a great idea. I love that. I mean, I've always heard the ministerial task and writing the offer on behalf of the buyer, but to flip it around is fantastic, because why not do it on behalf of your seller that you owe fiduciary duties to and say, hey, let's you and I go through these blanks. Let's talk about what you want in these blanks, and let's not give the buyer the first crack at it. Let's do it ourselves. And then the counter will be like 5 points or maybe 3, and you can get all that stuff in there. I think that's actually, I can't believe it. I'm going to say this, but I think that's brilliant.
This is being recorded, Damien. You might want to.
Oh, I better not
edit that out.
I regret it already.
All right. Should we get through maybe a couple more and then wrap things up?
Yeah, I think so.
I can go till 3:30 if you guys want to go another 10 minutes. I'm happy to do it.
Let's do that. Let's get through 3:30 and see if we can get as many as possible.
Okay. If the seller has directed their listing broker to advertise that they are offering buyer broker compensation, can this not be posted on the MLS since it is a directive from the seller themselves?
No.
Nope.
No.
Yeah,
I'll tell you a very quick funny story. The answer is easy. I'll tell you a very quick funny story. This came out of an MLS here in Colorado, and it was a hotline caller. And I hope she doesn't mind, but there's none of these names. Her last name, it was Cooper. Listing broker, last name's Cooper. She had on this, she was entering her listings after the 15th when the practice changes went into effect. All of her listings got delisted, like automatically. And she was contacting the MLS. She couldn't figure out, why is it getting delisted? What's going on here? And it was because COOP was first 4 letters of her last name. And so it was delisting her properties because these MLSs now have all of these things to make sure that no offers of compensation are going on. So it was this automated program that was kicking the listings out because those 4 letters were appearing in a sequence. So I say that because you're not getting around this. The MLSs, if there's one rule I can promise you, they are all obsessively enforcing, is anything for any reason related to compensation to a cooperating broker that may be listed in the MLS. So good luck with that.
And they don't care where it's coming from.
No.
All right. Are you saying we need to send brokerage compensation agreements before we send an offer? As a listing agent, I don't like that because it hasn't been negotiated yet.
Well, what we're saying is if they're going to do 29.3, then you better have a brokerage firm compensation agreement in your hands. And if you're the listing broker, I don't know why you wouldn't send out brokerage firm compensation agreements to everybody. Advertise the fact that, hey, the seller's paying this much. We're doing this. This is what we're offering. That's the way I see it. I mean, if you're doing it after the fact, what's to stop the listing broker for putting 0 in the blank and sending it to you? I mean, that would be a problem. So, Scott, you have any?
Yeah, no, so was the question based from a listing broker's perspective, why do they have to sign a broker firm compensation agreement? Was from the buyer broker perspective?
I read listing because they said it hasn't been negotiated yet. I'm like, well, why wouldn't you negotiate it beforehand? Why wouldn't you just send it out? Say, this is what we're offering.
Yeah.
Go.
Well, so so related to that point, I'll say this. People are like, oh, gee, I'm not comfortable signing a bunch of these brokerage firm compensation agreements because I don't, there's just too many contracts or offers of compensation out there. Let me tell you what you've been doing your entire careers as a listing broker. You have been entering your property on the MLS, putting a percentage or dollar amount into the offer of compensation on the MLS, and you've offered that to the entire population of your MLS, every single listing. You've done the exact same thing. You've said, hey, if you bring me a buyer, then I will pay you this. And so now it's odd to me that listing brokers are like, well, I'm not so comfortable signing that agreement or too many copies of that agreement. No matter how many you sign, you'll still be signing a lot less than you were previously committing to the entire universe of your other MLS participants. So I think you got to get over it and be willing to sign those things.
There was a time when that first brokerage firm compensation agreement came out, and Scott and I were involved in the drafting of that, along with 5 or 6 other lawyers. I mean, that was not just one person drafted that thing and sent it out. And we worked hard as a group to try and make sure that we covered all the different contingencies about when that thing terminates and all this to try and make it so the risk was not that high for you guys to send those. And there was a risk, I think, originally when we didn't have language tying it to the contract. At that, you have these agreements out there, and if something changed, then they might be stuck. But guys, since we've changed that language, I don't see the downside of signing a bunch of those anymore. And I agree with Scott. I mean, you've been doing it your entire careers. This really isn't any different. So, I know I had expressed some concerns originally, but the changes that we made to that brokerage firm compensation, or the bar made to it, I think that alleviated those concerns.
So if we are filling out 29.3 for broker to broker compensation, then in the listing agreement, do we still need an amount in 7,111?
If you don't have an amount in 7,111, you should not be filling out the brokerage firm compensation agreement. It's that simple. 7,111 should have an amount in it that matches your brokerage firm compensation.
And 29.3 should match that. They should, all those need to match if you're a listing broker.
Has VA relaxed their requirements of the buyer not paying compensation?
Yeah, what they did is they suspended enforcement of the rule indefinitely. And so I think that's just to buy them time. My belief is, and this was all as a result of the settlement agreement and the implications of that on veteran borrowers. So they suspended the enforcement of the rule, so it's not in place. And my guess is they'll do permanent rulemaking or permanent rule modification at some point in the next 12 months or so. But basically that whole concern has been, I think, completely alleviated indefinitely.
Okay, I am so confused now. Up until now, I have been hearing that the best place to put the unknown compensation is in 29.1, but now it sounds like you're better protected under 29.3. I am very lost.
Unknown compensation 29.1, known compensation 29.3 or 29.1. But if it's unknown, that means that you don't know if there is any compensation. All you know is what your buyer is obligated to pay you, and that whatever your buyer has signed an agreement to pay you, whatever percentage or dollar amount that is, if you don't know on a particular property for any reason, or I would even argue if you have not received an exclusive or a brokerage firm compensation agreement by the listing broker, then you should always put it in 29.1. That's for unknown. for known, yeah, if you know it and you have a brokerage firm compensation agreement, then absolutely put it in 29.3.
Yeah,
If
and
you
my
know it,
preference, my
go
preference
ahead.
would be to have a brokerage firm compensation agreement and use 29.3 for the reasons we talked about before. But if you can't, for whatever reason, then it's 29.1. Guys, like I said at the beginning, when we talked about this, there's no one way of doing business anymore. And that's what I think. I think everybody wants, oh, this is how I'm going to do it every time. I'm going to do a 29.1. I'm going to do this. There's consequences. There's consequences to sellers. There's consequences to buyers. There's consequences to brokers for each way that you go. And the way that you handle a transaction and the way that you handle brokerage firm or buyer broker compensation is driven by the market that we're in, by the particular seller, the particular buyer, the property that you're dealing with. You have to look at everything on a micro level now as far as how you're going to deal with things based on what the circumstances are. There is no one size fits all. You got to get out of that mindset. There just isn't anymore. And you got to look at what's best in this transaction.
Can you accept less at closing than what is in your buyer agreement? The buyer agreement says X% and seller agrees to less than X%. Do you need an amendment?
You can always take less. You can't take more without an amendment is the easiest way.
Yeah, and I'll tell you, actually, our buyer listing contract has language that says that if you do not disclose that the buyer owes you more, you waive it automatically, which I thought was a brilliant clause too. But, hey, I don't get credit for that one.
Okay, Rochelle asks, the last paragraph in 29.2 says, this amount may be modified between buyer and buyer's brokerage firm outside of this contract. Some agents don't want the seller to know there's any amount the buyer is paying. If this is left blank, can the buyer agent still collect the administrative compensation listed on the exclusive right to buy listing contract?
I think they can, but they better do it in writing before they sign a contract, because we have that language now that says that the success fee must be fully disclosed, or if there's any amount that the buyer has to pay different than what the seller and listing broker are paying, that it has to be fully disclosed to the buyer in writing prior to them signing a contract. So I think you can still do that, but if you're going to do that, you need to absolutely send an email or something before they sign the contract saying, hey, at closing, you'll be responsible for this. And I think that does alleviate the concern there if you really don't want the seller to know about the extra amount.
And I don't like administrative fees, but that's a separate discussion.
Yeah, I don't either, but yes.
Okay. This is a long one. The BD 24, page 3, compensation is not applicable to a customer when marked on page 2. Page 3 only applies to a transaction broker, as a customer is a non-represented buyer and has no agreement. Customers should have buyer compensation disclosed just as buyer or transaction scenarios. Page 3 does not allow that for customers. Furthermore, if the customer, say coming from an open house or the neighbor approaching as you place the sign on a land property, and they are a customer in an offer and you have a seller relationship, is messy. If the seller indicates in the listing agreement, what if any buyer broker compensation they are offering does not apply in the seller broker customer transaction, the broker in a customer and seller broker scenario can then only collect what the seller has stated in the listing agreement. If that is nothing, then the broker cannot be paid by or negotiate with the customer, or in low price land not meet a buyer broker minimum compensation amount. That is problematic.
Well, first of all, if you're treating the buyer as a customer, you have no agreement with them. You can't collect anything anyways. You don't have an agreement. Guys, anything that you're getting when the buyer is acting as a customer is coming strictly from your listing contract. And if you haven't built your listing contract around the fact of you double ending a deal, then you got a problem and you better go revisit what you're doing with your listing contracts. This is not messy, and it's really not an issue. You shouldn't be asking the seller to pay more compensation to you because you have both sides of the deal. That's just what it is. You should be building that into your listing contract when you take the listing. Scott, you have any?
Yes, I agree with you. I'm glad you understood the question, because it lost me after about the first sentence. But yes, yeah, that's another thing to consider, is that if your seller's not compensating or not paying a cooperating compensation, and you're just negotiating your own compensation, and there's no other meat on that bone, you might be double ending the work, but you're not double ending the fee unless you have some language that's going to address that in your additional provisions or elsewhere. But to Damien's point, that I don't think in any way, shape, or form you ought to be. Well, you can't collect it from a customer. If you wanted then to establish a transaction brokerage relationship and get the buyer to pay more, I suppose you could do that. But if they're a customer, you couldn't collect any commission from them. You can't perform any brokerage services for them.
Yeah, and frankly, changing to transaction broker and then asking your seller to pay because you're double ending a deal, that's going to get you grieved. That's going to get you a seller really upset with you that you're now asking for more than what you bargained for to begin with. I mean, I think all listing brokers, when they're doing their listing contracts, need to contemplate what they get paid or make sure that it compensates them for if they do both sides of the deal. I mean, going back and asking for it later in any form or fashion is going to end up with a complaint against you.
All right, it's 3:32.
Well, I was just going to say that I think it's like, yeah, you got to, as a listing broker, you got to figure, and this is probably a great place to close, but it's something else I've been telling buyer brokers a lot. And Damien alluded to it on the listing broker side. You got to figure out what you're going to work for with your seller, and you got to negotiate that, and then figure out the buyer broker's compensation, if any, that your seller is going to be offering. And that includes the possibility of double ending. The thing that I'm getting all the time now is buyer brokers who are like, well, this is so frustrating because I'm trying to get my buyer to sign an agreement to compensate me, and I don't know what properties they're going to see, and I don't know what's going to be what's going to be offered, and what do I do? What do I do? And this is the new frontier. You have to determine as a buyer broker what you work for. What is the value of your professional services to a buyer, any buyer, for doing what you do, which is pretty darn spectacular in the vast majority of cases. And so my example is like, when I was taking clients practicing law, if a customer or potential client came to me and they said, well, what do you charge? I couldn't respond to them like, well, what do you pay? Right. And our industry in some ways on the buyer broker world has been living in that world for a long time. And it's really what's gotten this, it's kind of what's at the heart of these lawsuits. And even though I don't agree with any, so much of everything that's gone on, there's some element there that we need to be better as buyer brokers. And that is, hey, buyer, this is what I do for you. This is how I earn my living. This is how I put food on my family's dinner table. This is how I pay my mortgage and my other bills. This is how I put gas in the car to drive you around looking at all kinds of properties all over the place. And so figure out what you work for, and whatever percentage or dollar amount that is, that's where, as a buyer broker, you need to be focused in your preliminary discussions with buyers in getting them to a point where they're signing an agreement to compensate you. It's not this sort of game of like, well, I could be leaving money on the table or I could not. You need to focus on what you're worth and what your professional services, what you charge for your professional services. And I think when we get past that kind of that mental flip, because you've never had to think of it in those terms before, I think again that'll separate those that survive from those that don't survive to those that actually really thrive. So I'll end with that.
Yeah, I think that's a good point. And guys, don't discount your value. I'm just going to tell you, as buyer broker, I think we have a habit of discounting what you're worth because you're in the industry, you're used to doing it, but there is a lot of value that you bring. And having that conversation, that tough conversation with the buyer needs to take place early. And you need to be comfortable with it. You need to be comfortable with the buyer understanding that, yes, I get paid for doing a job. And if you're not willing to sign something to pay me for doing that job, then maybe we're just not a good fit. And you got to get comfortable with that, as hard as it is. The plus side I will tell you is the NAR settlement is national, which means that we're going to see buyers getting more used to the fact that they're going to have to sign agreements if they want to go tour property, because that's just the new frontier. That's the new world. And I think that's going to make it a lot easier for you guys to get those agreements as buyers get used to the idea that this is actually now required nationally by virtue of what's come from the settlement. And so I think there is a light at the end of the tunnel that is not a train.
All right, let's wrap up there. Thank you, Damien and Scott, so much. You're both just such invaluable resources to our industry, to our brokers. We really appreciate your time today. Thank you, brokers, for joining us. We hope that offered some clarity. And thank you so much for your time today, everyone. And we will see you all soon.
Thanks, guys. Great seeing you.